Honestly, representing yourself in court is almost never a good idea, especially if you're facing life in prison without the possibility of parole. Lack of formal education, no high school diploma, no college degree, no law training makes it even worse. There are countless reasons why self-representation is risky, but I struggle to find a single valid reason why it would be smart. Now, brace yourself, because he's about to launch into a lengthy speech he's been eager to give. Prepare for some truly questionable courtroom logic.
So why don't you briefly share with me the things you want to get on the record?
Your Honor, let the record reflect that I'm an American State National, which is a private American. I'm here on a special appearance to administer the affairs of the All Caps Trust. I am the living man, Ricky DeMond Pierce, and not the All Caps Legal Fiction Corporation or dead entity. I stand on the land and soil jurisdiction, and that's the highest jurisdiction on the man. This is my oral request of me changing the court's jurisdiction over me here today. I have not contracted with the court in any kind of way, and I don't plan on contracting with the court in the near future. I have been forced to come here against my will and God-given rights under threats enforced by your government officials, which is kidnapping. Your courts have no jurisdiction over me, and I stand on the land and soil jurisdiction and have proof of it when I came to court on January the 30th, 2025. Your courts, plus in Louisville versus Motley, if any tribunal finds absent of proof of jurisdiction over a person and subject matter, the case must be dismissed. Your court's jurisdiction is the jurisdiction of the sea, which is the Admiralty and Maritime Laws, which is also a military tribunal, and the courts are known as a ship of war, a privateer, or a battleship. I am under public law, which is common law, which is also the law of the land, natural law, God's law. I have God-given rights that can't be violated, and the courts are under Admiralty and Maritime Laws, which is a foreign law to sea jurisdiction. See Article 3, Section 2 of the United States Constitution.
This next argument is difficult to follow. He cites Article 3, Section 2 of the Constitution, pointing to judicial authority over maritime and admiralty matters. But the Constitution never says that courts are restricted to those areas. In fact, when you read down to Clause 3 regarding trials, it explicitly mandates that all criminal trials be conducted by a jury in the state where the alleged crime occurred. Even his own reference undercuts his point.
And no living people live there, only dead persons, legal fictions, corporations, and dead entities. Because all cities are considered dead entities, which is another reason why you have to dismiss this case, because the living cannot be judged by the dead. Another problem the courts have, because my God-given right says I have to be tried amongst my peers and a jury of living people, which is American State Nationals, and also can't happen because our nationals is not under the court's jurisdiction and will not show one order because they hold a higher jurisdiction. In the original Constitution, Section 3, Article 3, Section 2 states that the United States, the corporation judicial power is under Admiralty and Maritime jurisdiction. And I am under the land and soil jurisdiction, and I have gave courts proof for this when I came to court January the 30th, 2025. I also mailed off my executive letter, the notice that President Trump sent out January the 4th of this year, letting all patriots know that these laws have been dissolved due to breach of oath, due to fraud and breach of oath for office. And I also mailed off a copy of my certified mail. I mailed off certified mail and have been received. I am also requesting your oath of office, Your Honor. The notice that Trump sent out goes as follows. Notice to patriots, date January the 4th, 2025. This is to inform all patriots that effective immediately, our government and government corporations are hereby dissolved due to breach of oath. Additionally, our statutory and foreign laws are also dissolved. The only legal framework that remains in effort are constitutional law as outlined in Article 61 of the Magna Carta and established common law. This directive is especially for corporate bodies and government workers. Any government corporate body, including police, judges, lawyers, and any individuals operating in these capacities must cease operation immediately. Those who continue to operate after this notice will be liable for prosecution for fraud and breach of oath. It is imperative that all government workers comply with this directive. Failure to adhere may result in serious consequences and even including potential military actions.
He can cling to the idea that political figures will somehow intervene, or he can accept the reality he's unlikely to see freedom again anytime soon. Reality isn't negotiable, and no external rescue is coming.
I declare on the penalty of perjury on the public law of the United States of America, the de jure government, from without the United States of America, the de facto government, and without the United States of America, the corporation territories. I reject, renounce, and remove all powers of attorney granted to me or issued under my name prior to this day. My birth certificate was the only contract that subjected me to these laws, but the birth certificate contract is void because I was only a minor and had no knowledge of this contract when it was constructed, which makes this contract void, which means the court lacks subject matter jurisdiction over me. I am no longer an employee of the government, which is the corporation government. I declare on the penalty of perjury on the public law of the capital T, United States of America, the de jure government, that I reject, renounce, and remove any and all alliance to any king or prince, any foreign state, any foreign government or flag. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, that I have never knowingly, wittingly, or voluntarily pleaded myself to any incorporated entity at all, but including but not limited to any incorporated church, synagogue, masjid, or temple. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, that I have never knowingly, wittingly, or voluntarily pleaded myself of any foreign state, foreign sovereign, or separated myself from my birthright political status as American state national. I declare, publish, and affirm on the penalty of perjury on the public law of the United States of America that I am a lawful inheritor, acting with full rights and authority, responsibility, and honor now and always while my tenure on earth shall last. I, the living man, Ricky DeMond Pierce, affirm and declare that I have returned to my lawful birthright political status as a Georgian, and I have copyrighted and trademarked the all caps name, which is a trust and not the living me. I have occupied my executive office and never gave the courts any permission to use the all caps name, which is fraud. I have over 40 violations that the courts have committed upon me and my God-given rights as American state national. And I have counted over $800 million in violations over the time that I have been incarcerated at Fulton County Jail, these 150 plus days, and it's only adding up as I sit in Fulton County Jail against my will and consent. And they are as follows.
1 point. He claims the government owes him hundreds of millions and even presents a personal fee schedule to justify it. It's a classic example of how far some self-represented litigants will stretch the law. These arguments rarely hold any legal weight, but are endlessly entertaining to observe.
1. These are all combined municipal and territorial notices of violations against Americans with failure to perform any and all occurrences listed below in this section, starting at $10 million. A. Notice of claim of sole relief and remedy. B. Notice of violation of the Lanham Act, attempted attachment and seizure of unregistered trademarks, Title 15, Section 1125, 8 and 11. Notice of violation of admiralty and maritime and prior cases, Title 25, Section 1331, 1, 2, and 12. D. Notice of violation for special maritime and territorial jurisdiction of the United States, Title 18, Section 7, 1, 3, 8, and 13. E. Notice of violation of the Postal Accountability and Enhancement Act of Title 39, Sections 1-3908 and 3621-3591. F. Notice of violation of Presumption of the Public Vessel Act, Title 46, U.S.C.A. Appendix, Section 781 through 790 as originally enacted. G. Notice of violation of the False Claim Act, Title 31, U.S.C.A. Sections 3729A and 7. H. Notice of violation of the Foreign Sovereign Immunity Act, Title 28, Section 1602 through 1611. I. Notice of violation of the United States Statute at Large Act, Title 12, Section 411. K. Notice of violation of the Geneva Conventions by the United States Department of Defense
Mr.
and United States.
Mr. Pierce, I'm going to just pause you for 1 second. You were on K. How many letters? I want to make sure
I'm
you're almost done because we're getting into international stuff and that's getting a little far afield.
All right. 2, private easements fee schedule. Penalty for private use, $250,000. These fees will be mandated upon the informant listed on the warrant, citation tickets, arrest warrants, detention orders, and seizure orders. Composing to produce trade name or other identification materials. A, name, $50,000. E, fingerprints, $200,000. F, photographing, $200,000. G, DNA, $5 million. Blood sample, $5 million. Personal property, trespass, carjacking, theft, interference with commerce or trade. M, color law, $150,000. N, implied color law, $150,000. T, fraud, $1 million. U, fraud upon the courts, $2 million. BB, stimulating legal process, $1 million. Use of trade name and copyrighted protected material on threats, duress, and or coercion. Name written by a informant, $250,000. Miscellaneous material written by a informant, $500,000. Court appearance fee schedule. These fees must be paid immediately after my case is finished. Failure to pay fines and fees will result in an additional fee of $5,000 for breach of contract. Demand for appearance in court. My appearance on a protest and duress per hour, 1 hour minimum, $75,000. Use of trade name material.
How many more pages do you have?
I have quite a few.
Okay, so I'm wondering if, and I'm not going to curtail you too much, but you'll be able to file that, which will make it even more of a record if you want it to be filed, or you could give it to me and I'll file it for you. But that's up to you. What I don't want to do is I want to make sure we're moving your case forward, and this is pretty lengthy. It might be more efficient to have it filed into the docket so that we actually see, hey, there it is in the computer system.
The judge attempts to maintain efficiency. But in cases like this, self-represented litigants often try to use courtroom formalities like magical exemptions to avoid standard procedures. To address it, the judge must formally record the arguments before moving forward.
I really need to get it on the record, and I need to file the motion to be able to address these issues also. I have the motions already wrote. If you give me a little time, I can get through it pretty quick.
Well, I don't want you to read too fast because Ms. Rivers needs to be able to take it down. Would you say we're more than halfway through, or are we not more than halfway through?
Yeah, we're halfway through.
Exactly half or more than half?
Exactly half, because it's 20 pages. I'm on 11 now.
Okay. Well, let's go. Don't read too fast, but don't read too slowly.
Trespass and failure to act fee schedule. Use of trade name material, name on a protest and duress, $25,000. Miscellaneous material, $25,000. Time uses for court appearance, 30 minutes on a protest and duress, $33,500. 60 minutes on a protest and duress, $75,000. 90 minutes or more on a protest and duress, $100,000. Trespass and failure to act fee schedule. Trespass by public officials, police officers, judges, detectives, attorneys, corporations, and other fictitious entities as well as any other who desire the contract. A, trespass on American homestead land, $10 million. C, failure of attorney to file requested FARA form, $1 million. Failure to accept American State National card, $1 million. Failure to honor God-given rights, $20,000. Failure to honor oath of office, $50,000. Failure to honor constitutional oath, $50,000. Failure to honor written and oral word, $5,000. Failure to honor a bond/no bond, $5,000. Detention from free movement and or cuff per hour, 1 hour minimum, $75,000. Incarceration per hour, 1 hour minimum, $75,000. Failure to follow federal and or state statutes, code, rules, and regulations, $50,000. Failure to set a claim upon which relief can be granted, $25,000. Failure to present a living injured party, $100,000.
At one moment, a sarcastic remark would be, shouldn't he be billing himself for this performance?
Total damages for each line set forth in a above schedule will be assessed as the total amount of damages as set forth herein times 3 for a total of all damages added to a 3 times the damage for punitive and other additional damages for a total of $1,019,631,000 US dollars.
1 billion, you're at to the B.
Yes.
Okay, that's a lot of money.
And that's just for the amount for me being incarcerated these 120 plus days. Your Honor, all laws are commercial, and all laws are not laws, but codes, statutes, mandates, regulations, and all the rest. And I'm a private American are not under commercial law. What's legal aren't law, Your Honor, and what's law aren't legal.
He makes the claim that certain acts are legal under his interpretation, but murder is both illegal and unlawful. That's a simple but critical point.
And Your Honor, ignorance to the law is no excuse, and that goes on both ends, mine and yours. This declaration is valid, true, correct, and complete in all jurisdictional law, air, land, and sea. Your Honor, let the record reflect that if you war against this is warring against the Constitution, and warring against the Constitution is called piercing the veil, and piercing the veil is called treason. Treason is punishable by death, and there is no remedy for treason. Also, in Orange versus Independence, officers of the court have no immunity from persecution when violating the constitutional right. I am honored the United States of America, the d'Ensues government, the Confederation of the States.
Mr. Pierce, there's one phrase you've used a whole bunch of times, and I don't understand it. The what government?
The d'Ensues government.
Spell that?
D-E-J-U-N-E, space J-U-N-E, d'Ensues.
D-E-J-U-R-E. Oh, got it. Okay.
d'Ensues.
Yep. Thank you.
Okay, which is the Confederation of the States. And the Federation gave the United States, the corporation, the de facto government, the power to operate out the 10 square miles, which is in Washington, D.C. And any laws outside of Washington, D.C. is commercial. And private Americans are not under commercial laws. We are under public law, which is common law. My God-given rights has been violated by being forced to give my DNA, fingerprints, eye pattern, and blood DNA against my will. I never consented to them arresting me or detaining me after I put them on notice of my political status. Your Honor, United States, the de facto government, is a for-profit corporation, which means they have a Dun and Bradstreet number, and no corporation can interact with a living man under another corporation. Your Honor, it states that every man is independent of all laws except those prescribed by nature. No man or woman is bound by any institution formed by his fellow man without his consent. See case law, Courtroom versus Neal, 2 N.C.338, May term 1796. Your Honor, in 1845, the then Pope and the British monarchs, both of whom were honor bound to act as trustees for the United States Trust, and both of whom acted in gross breach of trust, agreed that the American experiment was not working. The whole idea of self-rule was antithetical to the idea of divine rights of a king's supremacy. So they signed a secret treaty of Verona and agreed to undermine the American government. The British Monarch Commercial Company, which controls the bankers and lawyers, issued license to lawyers to act as privateers. That's why the Bar Association requires licensing. Acronyms for bar mean British Accredited Registry. Anytime we see the word license, it means that someone in a position of rulership is giving someone else permission to do something that is otherwise illegal. In this case, the king gave the members of the Bar Association permission to act as privateers against American commercial vessels. Because the jurisdiction where they attack us is international, admiralty, and maritime commercial laws. And that's why you see the gold rings around the flag, around that war flag, because the war flag is a war flag representing that the government is at war with the citizens. See 1864 Naval Agency and Distribution Act. Again, also, the United States was incorporated by the Pope, and the laws we are bound by are foreign laws from Great Britain, which means that the United States, the corporation, got Americans to bind by laws from Great Britain, which is also illegal. That's why, again, you have BAR, which stands for British Accredited Registry.
I've explained this before. Passing the bar doesn't reference some British registry. It refers to the physical barrier in the courtroom. To represent someone else legally, an attorney must pass the bar exam, which grants the right to advocate on behalf of others in court. Without it, self-representation or representing someone else is not allowed.
What page are we on?
What am I almost doing now? I'm closing now.
All right.
Again, I am 1, changed from jurisdiction of the courts. I have a high jurisdiction. 2, 2, I am demanding to see the state of Georgia to show up in proper persona. This must be made by self and not an attorney. 3, I am demanding that the courts present a living injured party because our citizens are considered dead entities, corporations, legal fictions, and artificial persons. I am requesting the judge oath of office and the first and last name of every court official in this courtroom before we proceed. I am demanding to see who gave the courts permission to use the all caps trust, which is a copyright and trademark. I am putting the courts on notice that I have occupied my executive office again, and I am standing in my full capacity as American State National, and I hold the highest court here today. I am demanding you give me a full relief of my case by either dismissing this case or giving me a bid bond signed and paid through my all caps trust. I am also filing an order of pro se ex parte with prohibition to dismiss my case for fraudulent practices, misrepresentation, and lack of subject matter jurisdiction. Your Honor, I, the petitioner, case will not being handled in the proper courts, which is common law courts. I, the petitioner, was not put on notice by a state-appointed attorney that my case will not handled in the proper courts. I, the petitioner, never signed a contract to be subject to the jurisdiction of the United States and or the District of Columbia. Again, the birth certificate and Social Security card are voidable contracts that was constructed when I, the petitioner, was a minor. So these contracts could have not been knowingly, voluntarily, or willingly consented to because as a minor, I, the petitioner, lacked the capacity to do so. Again, I am making a clear and unequivocal demand to petition the state to show up in proper persona. The state is a legal entity, and a legal entity is an artificial person. And an artificial person is a corporation, which cannot appear in proper persona. See case law, Penhollow versus DOANES. This vagueness doctrine may invalidate criminal law for 2 independent reasons. First, it may fail to get a proper kind of notice that will enable ordinary people to know what kind of conduct to prohibit. Second, it may authorize and even encourage arbitrary and discriminatory enforcement. Your Honor, a basic principle of due process that a law is unconstitutional if its prohibitions are not clearly defined. Plus, I, the petitioner, cannot owe a debt in a bankrupt nation, and no title of nobility shall be granted by the United States. See the United States Constitution. Again, Your Honor, I, the petitioner, cannot have a fair and impartial trial when the judge, the jury, the bailiff, the district attorney, and public defender all work for the state and are one and the same. See the case law, the Maggie Hammett case. Your Honor, the Constitution is a chapter of negative liabilities. Liberties, excuse me. It tells the state to let people alone. It does not require the federal government or even the state to provide services, even so elementary as maintaining law and order. See case law ID, period, CF.OLMSTEAD versus United States 277 US.438 and 478 1928. And again, Your Honor, any judge or magistrate who does not comply with his or her oath to the Constitution of the United States wars against that Constitution and engages in acts of violation of the supreme law of the land. The judge is engaged in acts of treason.
There's a misconception here that the judge is somehow committing treason by overseeing this trial. That's not the case. The judge ensures the defendant's legal rights are protected and maintains proper courtroom procedure. The defendant is simply given more time to speak than typical, but the process itself remains fair and lawful.
Your Honor, the authentication of my birth certificate signed by the Secretary of State, the Secretary of Washington, D.C., and the Governor of Georgia is admitting that the government made a mistake by making me to abide by a void contract and subjecting me to the jurisdiction and laws of the government when I had no knowledge of this contract and was too young to even know that this contract exists, that the government tricked me and my parents into without our knowledge and consent. And the courts have a copy of my birth certificate authentication also. Your Honor, I am a private American, which is American State National, and cannot be represented by a bar attorney because an attorney is an officer of the court and will automatically subject me to the court jurisdiction.
And I hear you on that, which is why we had the first part of our conversation, and I've concluded that you've got the ability to and the desire to represent yourself. We'll do that. I appreciate you making that record. As you and I agreed, you won't need to do that again. You've now made all those objections, made it very clear that there's $1 billion plus, and I get it that that number is increasing. Every day you're in custody and people are trying to contract with you when they shouldn't, all that. You've made a healthy record of that. You're welcome to file things now because you are your own attorney. You can now file things of record into the docket. But when we see each other again for whatever the next court event is, we can use a shorthand where you can say, I renew the objections that I made on the record when I was last in court. And that way you're not going to need to break your vocal cords by going through that again. But that was very thorough, and I appreciate you making that record.
So anyway, I can leave these motions here today?
So this one time, I'll take responsibility for filing things for you.
I can, you know what, I'll wait because I still have some other.
You want to do more work on it? Okay.
When the judge instructs a defendant to work on it, it really means to focus and organize arguments rather than submitting disorganized or irrelevant points. Before concluding the session, the prosecutor highlighted a critical issue: the defendant could be classified as a habitual offender. Conviction for major crimes under this designation means a mandatory life sentence without parole.
And Mr. Pierce is an ANC recidivist, so he is facing a convicted a mandatory life without parole sentence.
Okay, and is there a recidivist notice in the docket?
Not at the moment. I intend to file it.
Okay. Mr. Pierce, I'm going to translate that for you. You may already know what it means, but because of your criminal history, the state has the ability to file a pleading, which it sounds like they're going to do, that if you're found guilty, and all of this is contingent on a jury finding you guilty. If they find you not guilty, none of this matters.
Okay.
But it's a big if. And if a jury comes back with guilty, I had mentioned that the maximum possible penalty was life without parole. But if you'd never been in trouble before, that's not a mandatory sentence. Life, I'd have to impose life, but I have the option to choose between life without parole or life. Unless you've got sufficient criminal history and the state files this notice. And if they do that and they've got certified copies of your convictions, then that takes that discretion away from me. And the only sentence you can get is life without parole. And that may be where we end up, but they haven't filed it yet. When they do, we'll figure it out. But it's important that you be on notice of that, because sometimes the defendant thinks like, hey, you know what, if I'm found guilty, it'll be life. That's a long time, but it's parole after 30 years. But if life without parole is the only option, it just may make you think differently about the case. Don't know, but we'll keep you posted.
Even after being informed of these severe consequences, he continues to insist on representing himself. That decision will be explored in the next video, releasing next Friday. I also have another upcoming case from Georgia involving a similar self-representation situation, with an unusual outcome. If you follow these videos, hit like, leave a comment with your thoughts, and subscribe with notifications turned on to keep up with new content. This is Judge Talks, and we'll see you in the courtroom.